to the Air Force General Counsel's office from SMC, where he advised on numerous space major defense acquisition programs. Mr. Haig also wrote the first handbook of rights and technical data and computer software ever issued by a military department. Mr. Haig is also a member of the DFARS Patent, Data, and Copyrights Commission. Finally, we have Mr. Matt Ruane, who is an acquisition attorney with the Contract Law Field Support Center at Offutt Air Force Base, Nebraska. Mr. Ruane is the Senior Program Counsel to the Defense Technical Information Center, which manages a $30 billion portfolio of research and development across the Department of Defense and the Department of Homeland Security. Mr. Ruane is a former active duty JAG and has also worked in industry. So with that, I think I'd like to first turn to Bob Borich and and talk a little bit about kind of some of the changes to out at the Space and Missile Systems Center. I think it's an exciting time in space acquisition. There's a lot of changes with the establishment of the Space Force, a lot of congressional interest in space acquisition in particular, and I think in many ways SMC is right at the heart of a lot of these changes. And so Bob, I think without further ado, I'd love to hear kind of your perspective on some of these developments.
Hey, Damon. Hello, panel. I've worked with everyone on this panel, some for many years, maybe too many years. But hello, everyone. Great to be here. We've had a lot going on at SMC over the last 3-4 years. We transitioned to a new organization called SMC 2.0. And then shortly after that, all of a sudden the Space Force came along. And now we're transitioning again to the Space Systems Command. So a lot of moving parts going on. Now, just space or SMC 2.0, the background on that is we went from a vertical organization to more of horizontal, setting up cores. So like an area for production, development, enterprise, which kind of divides up the missions in different areas. And as part of that, the core leads are deputy PE. Just accidentally muted myself, sorry. And they don't necessarily, they don't directly report to the PEO for space. They have direct lines of communication to the service acquisition executive. So along with that, there was another organization called the Portfolio Architect that's doing a lot of the cutting edge initiatives that the service acquisition executive was very interested in, and that was Dr. Roper previously. And they were doing a lot of that on behalf of the Corps. So a lot of things going on, and also the idea of kind of delegating down to more junior personnel as acquisition officers to make things happen and to work directly with the service acquisition executive. So it's created quite a dynamic for us as lawyers to kind of know everything that's going on and try to get involved and give them the right legal advice. And we've really been stretched into new areas where we don't necessarily have expertise, which I'll mention in a moment. But as part of all this, becoming the Space Force and now transitioning to the Space Systems Command, which, by the way, makes us kind of like a mini MAGCOM, where we're going to have the ranges under us, Vandenberg Air Force Base, Patrick Air Force Base. So we're getting an influx of work, transfer of missions. We're picking up a Navy SATCOM program, UOS. A biggie for us is that we're looking at taking over the DIS SATCOM leasing of commercial SATCOM bandwidth, and DIS has been doing that for 50 years, and so that's one area now. Not only is it a manning issue, but kind of an expertise issue to know what we're doing. So we have an expanding legal issue portfolio, areas involving international law, kind of fiscal kind of law setups that we're not used to, capital working funds, revolving funds, things that we haven't traditionally worked on here at SMC, but we have through the portfolio architect. By the way, also has a chief partnership office who has been setting up all sorts of dynamic agreements, memorandums of agreement, memorandums of understanding with different countries and domestically, and creating arrangements under which we can do some very interesting acquisitions. But to give you, and by the way, I'll talk about OTs later, but OTs now seem like traditional procurement structure at this point, as far as I'm concerned, with a lot of the new stuff going on. But some things that were kind of dynamic, I know, there was an Air Force pitch day. We had an Air Force space pitch day, I think about a year and a half ago. And that was just, and that was contracting with non-traditional contractors, small business, innovative research contracts, and something that was going gangbusters. And it was something that we kind of caught up with late, but very interesting to have an event at a hotel, which was basically, the final stages of a source selection with oral presentations from all these companies with very senior leadership there, and you basically have an SSAC and trying to figure out how to keep that under control and document it. It was very interesting, and we were very cognizant of the Air Force pitch day had some protest activity, so that was kind of one of the first kind of Space Force things that was interesting, and we ended up videotaping and having the leadership document things as best as possible, so we had some sort of record. So now, recently, we've been into International Space Pitch Day, which was an initiative that came out of Portfolio Architect. They were working with AFWorks, and again, junior folks, driving that, and a great job. But that's something, out of many things we had to kind of back out of and get it done right. But it was a very interesting way we pursued that through an international agreement with the United Kingdom. And actually, United Kingdom did the contracting on behalf of us. But I think, my message of kind of where our challenges are is figuring out where the appropriate expertise is and marrying up with that. And International Space Pitch Day was a great example, because we had a great team of lawyers, and typically, like, if it's a big acquisition, you might have 8 acquisition lawyers on there. Well, they're all acquisition lawyers, but this team, we had lawyers from GC, maybe 3 or 4, but each of them had different areas of expertise that we were able to advise and put this thing together successfully. And so that's kind of the challenge with a lot of these new things coming up. Like I mentioned, like the chief partnership office and portfolio architect. I mean, a lot of we've gotten a lot of MOAs and MOUs, and it was interesting because, and I think we have a pretty good handle on this now of getting a good template for stuff like that, and also getting the correct coordination, obviously, with SAF-IA and the international attorneys to make sure that's all being done appropriately. But with these MOAs and MOUs, we were getting like 20 different versions. Some and a lot of them were good, but seemingly some were, though, written on a napkin during lunch. So those types of things that we're dealing with is kind of just figuring everything out and getting the clients trained and knowing to use the appropriate channels of expertise, like contracting and other things. I would say, first of all, I have a fantastic legal team. And as far as the traditional mission areas like MilSatcom, GP, launch, infrared stuff, all doing great work. And I'm just kind of bringing up kind of I chose myself to kind of be the lead for portfolio architects. So I have a lot of insight on this stuff. But we've, things that I get emails, and it's really exciting, but also difficult. Sometimes I get emails and I stare at it for a day because I don't know what it is and I don't know who to coordinate with. And I got to just kind of let it seep in my brain to figure out. And you hate to go to the client and say, hey, this is not my area, and volleyball it over to somebody else, but I try to help them and figure it out. But I mean, I've had, inquiries about, hey, do you have a attorney with commodity exchange experience? No. Well, they wanted to set up a space futures commodity exchange, get it going by this summer, and things like that. You're like, all right, there's some issues there, obviously, and I mean, I think the worst story about that was we actually, and this idea of having expertise and finding it was, unfortunately, there was a situation where somebody had actually tried to go to a GSA contract and hire a law firm for commodities exchange experience. So obviously we caught up with that, put a stop on it. So things like that are kind of going on, but for the most part, really cool dynamic stuff going on, moving fast, obviously forward leaning. So, more risk taking going on. We're an organization. At one point we used to brag we hadn't lost a protest in 30 years. Jim was part of our organization, he'll remember that. And now since then, just the way we're operating, we're getting more litigation, and we're kind of resigned because of the risk taking. We're not gonna win every battle, but we've been winning the big ones, and that's that's always gonna happen. So coordination, finding the right legal expertise. I'd say some concerns I have is advisory and assistance contractors, just the advent of those assets and the things they're doing, and often getting contacted by them for legal advice. And I just think that's an issue. I don't want to go too much into it, but I think that's an issue that we all need to deal with as our programs hire ANS more and more on what their role is. Our big challenge too is with the Space Systems Command setup, manning issues. We were down 3 slots. We're finally fully manned, but now we're not because of these different missions coming in Space Systems Command and all that. I did want to mention, and we're doing more initiatives that we're talking about now, about more contracting with foreign-based companies to get the advantage of their cutting-edge technology and ideas, and obviously a bunch of issues to work out with that, since we haven't traditionally done that. And I'm not talking about per international agreements, but more kind of local SMC-based stuff. But one big issue that we've been grappling with, which is a big one, but I think we're making progress, and I think we will soon, is just and this is just not, I mean, it has to do with foreign-based contracting, but any contracting just based on working with non-traditional contractors, that there's foreign investment involved with these companies and foreign ownership. And how do we resolve those situations? How much of foreign investment is too much, or is it zero, or what? So we gotta, and most importantly, we need to have a process to figure out, because we can have some pretty vital contracts there, and all of a sudden some concerns are raised by investigators. Hey, they have this, they're invested in by this company or by individuals from Ukraine or something, and all of a sudden can bring a vital contractor on a vital mission to a screeching halt. So we have to have a way to resolve those things quicker and know how to do it. So we're working on that.
Yeah, Bob, if you don't mind,
Yeah.
you had mentioned other transactions,
Yeah.
and I think in many ways, I think SMC is maybe sort of at the forefront of using other transactions. You've kind of a sort of a pioneer, I think, or in the earlier days, with the EELV program, originally, using OTs to develop the launch systems, and then now with the most recent, update and new phase to modernize the launch fleet, again, used a series of other transactions to get that development work underway. And so I was just wondering if you have any kind of thoughts. You mentioned sort of how routine kind of other transactions have been there at the center. I was wondering if you could talk a little bit about kind of how SMC is approaching other transactions, and any kind of advice you'd share with folks about using OTs.
Okay. I would say, number one, we've always used a very stringent, going back to the launch ones, which were huge dollar OTs, we used a very stringent source selection and process, very disciplined. And so, and we're very happy to say we had some major litigation with those agreements. And the first one was the challenge to try to get the Court of Federal Claims to take jurisdiction on one of the agreements as a procurement contract. Well, we won that. That was dismissed, and then the case was refiled in the Central District of California, which was a court in Los Angeles, and we won that protest quite convincingly. So we've got some good, solid case law to back us up. Now, I think still, though, whenever you do that, the impression is to the clients, hey, these things aren't really protestable. We want to go fast. We want rapid prototyping, cut corners. So I think we continually work that with our teams. And let's make it clear. I know there's some articles out there that we have government teams that conduct source selections, and we're, as lawyers, we make sure they're as disciplined as possible, reasonable and well documented. But the decision on these awards are done by a government decision authority, not by the consortium manager when you talk about the spec OT. And that's where we're getting a lot of business now. And I know Sam Novello will talk about the spec OT who's involved with that. It's now has a cap of like 12 billion over 10 years. So I think, we have a good process down. We have good templates. And to the extent, we do these source selections, we've been talking about it very recently. We gotta ensure that we don't ruin a good thing by not meeting at least the requirements of being fair and reasonable under the APA.
Yeah, no, excellent. Yeah, and so you mentioned the spec OT. One of the I guess the original spec OT was a lower dollar value ceiling consortium, other transaction, and then recently SMC awarded the much larger Space Enterprise Consortium follow-on agreement with a 10-year ordering period, and 10 and up to $12 billion ceiling. So I guess with that, I would like to turn to Sam Novello, and I guess maybe get your thoughts on kind of the some of the challenges with using other transactions, some of the with the kind of the growth of these consortium other transactions, kind of from your perspective in OSD, what do you think folks ought to be kind of watching out for as more and more of this development activity is being done through these instruments?
Sure. I am audio only, so I will proceed with that. We have found that OTs have caught on across DoD, not limited to those in space. Folks are oftentimes using OTs, as was mentioned, for speed, but really that's not the sole purpose for OTs, and with speed comes risk. And so generally some of the observations from my perspective, not speaking for OSDGC, is that we need to ensure that we address, to the extent necessary, intellectual property, which I know we'll be talking about on the panel a little later. What do we seek rights in? There is nothing that prohibits an activity if they choose from including IP clauses or specially negotiated licenses with these non-traditional vendors. And so sometimes for the sake of speed, we sacrifice perhaps what our long-term needs will be. I know SBIRs were also mentioned. Again, I think the practitioners need to make themselves aware of the data rights that flow with SBIRs. Those data rights have, the duration of those data rights have changed over the past couple of years. But while in general procurement, the data rights follow the money, that is not the case for SBIRs, and those, even with full government funding, are rights that are restricted for the government for an extended period of time. Again, not saying not to utilize SBIRs or to be weary of OTs, but simply to take into consideration those concerns. I will say of recent, the practitioners certainly will be familiar or should become familiar with the Oracle protest, where Juris GAO found jurisdiction, basically arguing whether there was should have been conducted as a FAR contract, and whether going from a prototype to production was sufficiently advertised, for lack of a better term, such that and whether the prototype had been completed prior to the production decision. We just had a non-concur. I issued a non-concur on a production effort that was an OT issued by another service, and in that case, there was a consortia that was solicited under a very broad work effort that covered things such as enterprise services, command and control, cybersecurity, and the like. And some narrative addressed that in original Fed Biz Ops, but in this case, a task order was competed for essentially a commercial service, which was defense travel, to be prototyped within the department, and then a production decision was requested. The concern and the reason for our non-concur with that effort was based on a couple of different lessons learned from the Oracle decision. One was that from the originally competed consortia effort, that unlike the space efforts that are more focused, there was no indication that efforts such as DTM work, defense travel, would be included in that effort. In that case, a separate Fed Biz Ops notice was issued, which indicated, hey, the department is considering either use of consortia, the effort to satisfy DTM, or a FAR-based contract. It indicated this was not a request for white papers, and essentially that no decision had been made. While the production efforts and scope efforts were included to the participants in the consortia, no other vendors were made aware that it was likely this effort would be done with the consortia, which in this case was C5, is the name of the consortia. and secondarily, that production would be envisioned. So there was no nexus, if you will, no opportunity, similar to Oracle in some respects, for alerting vendors that we are going forward with an OT, and specifically mentioning the likelihood or the possibility of production. We did not, as in Oracle, have an issue with completion of or not being complete in the prototype effort. In this case, the prototype had been completed, but there was no nexus to the underlying OT notice that would put offerers on alert. We also have a secondary concern just to be aware of. In the case of this consortia, vendors have to join the consortia in order to bid on work. There's obviously a litigative risk associated with that another party may claim essentially a pay-to-play type of arrangement, and that could be challengeable. So something to keep an eye out for. And also even the terms of the consortia agreement with regards to, as Bob had mentioned, to ensure that they are not performing inherently governmental functions by racking and stacking proposals or otherwise doing what is government type of effort. One of my colleagues had mentioned that actually a couple of private sector attorneys in a recent meeting, training session, had raised that issue of inherently governmental as a concern that they've been seeing from industry writ large, although there has not been any litigation associated with that. So the lesson learned, at least for my perspective, is to not have these very broadly drafted OT agreements, have them focused in the areas that you're looking for, take into consideration whether prior to issuing a task order, you, to mitigate risk, want to simply send out a Fed biz op saying, hey, we're going to be doing this X effort under this consortia agreement. If it's not clear from the face of the underlying OT Fed biz ops, that scope will be considered and essentially treated as similar to a scope issue in a FAR-based contract. And then lastly, perhaps, but not the least, is, as Bob had mentioned, there's a lot of interest in space, a lot of efforts that are ongoing. Of recent, we had an issue where Space News had indicated that they thought the department was going to start building a base on the moon, and that was a violation of the space treaty. And you know, we tampered that and worked. We actually received calls from the Department of State on that issue, counsel's office. But again, to be concerned or at least aware of what type of international type of treaty issues may arise in the case of doing manufacturing on using elements from the moon and the like. Even the mere mining, if you will, of things from another planet could raise treaty concerns. So that's a concerted effort, kind of an effort to include, you know, Intel and international and the acquisition community. And I would be also regretting not mentioning that when we do the OTs or FAR-based contracts, that we do, as our IP presenter will indicate, consider architecture. And, hand in hand with the IP rights, are we requiring an open modular system architecture? That ability to plug and fight, if you will, with the modularity becomes critical, especially for assets that, are something that we can't physically get our hands on, but we're doing, software modernization of satellites and the like. And so to be able to have requirements such as standard non-proprietary interfaces would allow for increasing both lethality and also doing what perhaps we used to call pre-planned product improvements. So, OTs are simply a tool, but the same thought process in many regards that an acquisition attorney would think about for a DFARS contract should stay within the practitioner's mind under an OT to obtain the best product, for the taxpayer. Over.
Okay, yeah, no, I think that's excellent, and I think we'll turn to Jim now to talk a little bit about modular open system architecture, and how it applies to space programs in particular. If we have a little bit of time at the end, I'd love to return to you to talk a little bit about the recent rewrite of the 5000 series, and the adoption of the adaptive acquisition framework, and any thoughts you have about how it does or doesn't maybe impact space programs especially, but just to be safe on time, I think let's turn to Jim now to hear a little bit about a modular open system architecture. So Jim, with that, over to you.
All right, thank you very much, Damon. Morning, or I should say good afternoon, everyone. My name is Jim Haig. I'm one of the Air Force General Counsel's Office attorneys assigned to the Air Force Smart IP cadre. And what I'll be doing here is briefly discussing the statutory mandates associated with a complicated system and software engineering concept. Now, I've included those statutory mandates and other relevant information in the backup slides in the interest of time. I will not brief those, but I do want to emphasize that it is critical that attorneys, program counsel, and in-house counsel for major defense contractors understand those statutory definitions and related definitions of system engineering terms so they can advise their clients how to properly draft and respond to requests for proposals consistent with those definitions. I'll also brief you on the results that can be achieved from 3 different perspectives if the United States Space Force properly implements those statutory mandates, and I emphasize the word properly. So if we could please go on to slide 2. Over 2 years ago, I attended a training event on open mission systems and UCI, sponsored by the Air Force Rapid Capabilities Office. The approximately 400 engineers and program managers employed by major defense contractors who attended, I may have been the only attorney present. The keynote speaker was General Raymond, then the commander, Air Force Space Command. General Raymond began his remarks by stating his speech would probably be the most important one he would give that year. Now, understandably, that comment concentrated my mind wonderfully. But what really piqued my interest was how he explained why he thought MOSA was important. So the purpose of this presentation is to give you some insight into why attorneys need to understand this topic and how to assist their clients in reaping the benefits of MOSA Congress intended. Next slide, please. These are the topics I'll brief you on today. Please go to slide 4. Ladies and gentlemen, this is the bottom line up front. In my 31 years practicing government contract law, I've never seen the level of detail Congress mandates specific documents contain, as is the case with MOSA statutes. Presumably, that is due to the fact that Congress wants to make it clear to requirements personnel, program executive officers, program managers, contracting officers, and our industry partners that they are dead serious. Now, Section 804 of the FY21 National Defense Authorization Act, mentioned on the first sub-bullet there, indicates the purpose of MOSA is to, quote, advance the efforts of the department to generate diverse and recomposable kill chains, end quote. And now you know why the title of my presentation uses that military term. Keep in mind the Joint All-Domain Command and Control, otherwise known as JADC2, clearly has space implications. Now, to better understand the benefits to be reaped if the U.S. Space Force properly implements those statutory mandates, I offer three different perspectives for your consideration. That of the warfighter, that of the acquisition professional, and last but certainly not least, that of our industry partners. With that, if you could please go to the next slide. Here's the first pièce de résistance and its pedigree. By pedigree, I mean I've given you the citations to where I'm obtaining these particular statements or positions. The DoD instruction is the one that Ms. Lord issued out just 2 months ago, entitled Acquisition Intelligence. Please go to slide 6 now. Here's the second pièce de résistance and its pedigree. Now, one other benefit beyond that mentioned on the slide is enhanced risk management, and that MOSA is one solution to the perennial problem of diminishing sources. Next slide, please. And here's the third piece de résistance and its pedigree. The first resource cited there is the National Defense Industries Association, a trade association comprised of the major and smaller defense contractors. This is the benefit industry perceives. They can save money and increase profit margins. But, please go to slide 8. What NDIA also said is these quotations. MOSA is highly dependent on the taxonomy level of the system. For those of you who may remember high school or even college biology, yes, we're back to the careless Linnaeus days. Taxonomy, definitions, levels of indenture of the work breakdown structure, as NDIA mentioned. That's why attorneys need to know these kind of topics. And according to NDIA, the MOSA strategy must be in place prior to the RFP release, which therefore means the program manager needs to understand the level of system modularity. The PEO does, the contracting officer does, the program council does, in-house council of major defense contractors do as well. Next slide, please. So, how can you help the Chief of Space Operations implement a MOSA? At the risk of taking a position that might be construed as arrogant, here's some points to consider. 1, make sure your programs carefully read these topics and the statutory and regulatory policy documents that I've cited in the backup slides. Become familiar with the weapon system, especially with its work breakdown structure and its proposed software architecture. 3rd, read these programmatic documents to the extent you are permitted to, because some of those documents or portions thereof, of course, may be classified. But that'll give you, or should give you, an idea of what is the system level of modularity intended so the warfighter can achieve the objectives I described in approximately slide 5. And then last but not least, ensure their RFPs and resulting contracts are consistent with those policies and statutory mandates, acquire the appropriate deliverables required by the CDD, CEP, AS, and LCSP, and contain MOSA requirements, including the IP deliverables and associated license rights that are unambiguous and unenforceable and enforceable, because that's in everybody's interest. Because except for those people that are full-time trial attorneys who like job security, we probably have better things to do with our time than fight things out in bid protests or in post-award Contract Dispute Act disputes that could have been minimized if we would have more tightly defined our requirements up front. If we could now move on to the next slide, please. This is probably the crown jewel of any weapon system request for proposal. For from that document flows the statement of work that requires our industry partners to deliver the IP deliverables and associated license rights we need to implement MOSA in enforceable contract language. You'll find the statutory definitions of the words highlighted in red in the backup slides. Those are basically the sections that are straight out of that MIL handbook, which provides this DoD's template for a system requirements document, or MIL Standard 961E, DoD's Bible for drafting up performance specifications. Next slide, please. Your statement of work. It should identify what level of modularity the program manager wants. And it should require that those major system components and modular systems, and there are statutory definitions now for those terms, shall be partitioned into discrete, cohesive, self-contained units so that we can plug and play, or to use the UCI term, plug and talk. And the interfaces have to be identified in the RFP, because that's what 10 U.S. Code 2320 requires. And that's just one type of deliverable that is necessary. The other types are identified on the next slide. So if we could go to that one, I'd appreciate it. Now, in some industry circles, the word deliverable is a talismanic concept. That is to say, if a contract does not require submission of the intellectual property in question via a DD Form 1423, some of our industry partners take the position that if the government did not require delivery of intellectual property via that DD form, the government either, one, acquires no license rights whatsoever, irrespective of whether DoD funded 100% of the development of that intellectual property, or two, acquired whatever license rights it did under the contract, but it can never exercise those rights because the contract did not require the contractor to deliver that intellectual property, such that the government does not have physical possession of that IP in its hot little hands. The legal term here is called inchoate, I-N-C-H-O-A-T-E, rights, incompletely formed, floating out there in the stratosphere, if you'll forgive the pun there. But not so if you make everything a DD Form 1423 CEDL deliverable. So recently, the Air Force issued out the pamphlet that is identified, or Ms. Costello did. And these are the type of deliverables it recommended, the 4 types. A depiction of the software and system architecture, performance specifications, the modular system interfaces, because that section of 10 U.S. Code 2320 requires that the RFP identify the interfaces. That's what Congress wanted. And that's an example right there of micromanagement that I alluded to earlier. And then finally, verification, validation, technical data that to determine, well, once that satellite shows up on the loading dock and the contractor submits the DD-250, how do we know the thing actually was designed and built consistent with the MOSA principles baked into the contract? And the last but not least, on the computer software side, that type of computer software, or those types, I should say. And the reason why I foot stomp the notion of deliverables is because DoD's Bible on Configuration Management, otherwise known as MIL Handbook 61 Bravo, warns all readers in uppercase letters, do not substitute access for delivery. Now, I encourage those in the audience who take the initiative to read that sentence in that DoD publication to ask themselves this question: when have I ever seen in my career any DoD publication that ended a sentence with an exclamation point like that one does? In other words, the concept of intellectual property is like the silver dollar in your pocket. A silver dollar has 2 sides, heads and tails. If both sides are not properly stamped, that coin is not legal tender. And so it is with intellectual property. The contents of the deliverables is one side of the coin. And the other side of the coin are the IP licenses to that content. Because as DoD Instruction 5010.44 puts it, Data or software and deliverables are of no value unless and until the license rights to it are attached and the US government actually obtains and accepts those deliverables. Keep in mind that by statute, DoD never acquires ownership of IP. It only acquires physical possession of that IP accompanied by a license to that IP content. So unless you have both the IP deliverable as well as the appropriate IP licenses to that deliverable, you have nothing, period. End of discussion. Since this slide discusses the head side of the coin, let's now turn to the tail side of the coin. Next slide, please. Now, based upon my personal experience, I think it fair to say there are a number of requirements personnel and acquisition professionals in DoD that possess a mistaken belief regarding what is an IP license based not upon formal training or careful reading of the appropriate resources. Instead, that mistaken belief is based upon what they heard over the water cooler decades ago. So the purpose of this slide is so that you can assist me in spreading the word so that minds are properly calibrated in this regard. And in the parenthetical, I've given you the pedigree for this particular concept, that any IP license is based upon those three parameters: person, purpose, period. Just like on that piece of plastic that's in your wallet, otherwise known as your driver's license. Please go to slide 14. The first bullet on this slide is, of course, the Twin Towers litigation resulting from the total destruction of those buildings on 9/11. The Second Circuit spilled gallons of ink on 140 double-column single-space pages of text in order to arrive at their decision. They trudged through the laws and judicial decisions of all 50 states and various insurance treatises. And when they completed that task, they found in favor of the owner and against the insurance company. So the $3.5 billion question that I assume the insurance company's board of directors asked themselves after reading that decision was, when underwriting the insurance policy for the Twin Towers, did our chief executive officer price into the insurance premiums the risk a court's interpretation of the single word occurrence might double the required payout from $3.5 billion to $7 billion? I have no idea what is the answer to that question. In any case, I'd submit the critical takeaway from that somewhat large data point applies to the topic that I'll brief you on today, and that is the Space Force has better things to do with its time and money than litigate, bid, protest, or contract claims caused by ambiguous language in RFPs and contracts regarding what were its most requirements for a particular weapon system. And with respect to the second bullet, I don't think I need to remind this audience of the identity of our potential adversaries, much less their intentions, much less their capabilities. Next slide, please. Ladies and gentlemen, that concludes my presentation. I thank you for your patience. I look forward to answering any questions you may have either now or in the later breakout session, and regarding how this complicated engineering and legal concept needs to be optimized to put the right tools in the hands of the warfighter at the speed of relevance. Damon, over to you.
All right, thank you, Jim. That was fantastic. We're going to turn to Matt now. But one thing that I hope if we have time today, or more likely, maybe in the breakout session, I'd love to hear your thoughts on, with a lot of programs now kind of starting off with some prototyping and a consortium other transaction, what should they be thinking about in terms of IP in particular, since, as we've talked about, the data and the data rights, the data rights flows from, sort of under a traditional procurement where, who's paying the money, and that paradigm does not necessarily apply to another transaction where, we don't have those clauses to fall back on, and we maybe need to be more proactive about getting off on the right foot in terms of intellectual property. So if we have time, maybe at the breakout session, I think that'd be fantastic to hear about. But with that, Matt, I want to turn to you. And I understand that you wanted to talk a little bit about how the space traffic management function has evolved in recent years, and with it moving from DoD over to the FCC, how that might impact some of the some of the way we do acquisitions, and some of the kind of the regulatory activity that's taking place with the FCC. Kind of what your thoughts are on how that's going to maybe drive the adoptions of standards, how it's going to impact the commercial market for space technology, and consequently affect DoD's acquisitions, since so much of what we do is draws on what the private actors are doing. So with that, I'd love to turn it over to you.
Can you hear me?
Yep, loud and clear.
Can you see the screen share I have? My slides.
It's showing up for me.
Perfect. Thank you so much. Pleasure to be on this panel with all of you, Bob and Jim. We've worked together for years, and hopefully what I have is a good has some good segues and some good other ways of looking at some of this stuff. Plus, as Damon asked, I want to talk about some recent developments, what I think is the most significant development in space situational awareness, space traffic management, and strangely acquisition in not the FCC, but the Department of Commerce taking on the lead role for SSA from DoD. The FCC has put out a rule in conjunction, hopefully with the interagency process, that I think benefits acquisition. But if I can go from first to 50 feet and give some examples on data rights, and then go to tech transfer under data rights, and then go into outer space, talking about the FCC proposed rule and the transition of SSA, STM from DoD to Department of Commerce. So those are the two topic areas there: software, data rights, and tech transfer, and cross-discipline legal coordination, which is what you have to do to understand, I think, the impact of standard setting and national regulation, potentially international regulation on SSA and STM. That's you have to be an acquisition lawyer and a space lawyer, international lawyer, and an admin lawyer, or at least you have to talk to those guys. So why do we, just to kind of pound Jim's drum from a different angle there on data rights, why? This is a slide that I think I originally started to develop this somewhere around 2008 when I was working in industry, and our company was working with the Air Force Academy to present some procurement law and some procurement process, some corporate processes to Air Force Academy cadets. This is a similar slide to what I gave them. For all these reasons here, it's important to spend the money properly for the warfighters, to stay on procurement schedules, to not violate laws, and to have robust and fair competition, because robust competition gives you better products. On the top right, you see the PAVPAWS radar, a radar developed in the 60s and 70s. There's a little truck there showing how large it is. And on the bottom right, you see a blade server. Lots of companies build blade servers. Only one company built for only the government funded the development of that phased array radar. And so we get different rates depending on who paid for the development. So the main bullets, just to say a different way what Jim said and what the recent developments, it's always been a case of the government needs to get what it pays for. Also incentivize industry investment. It is not in the government's or the industry's long-term interest to reinvent wheels. Sometimes companies think it's in their short-term interest to claim data rights that they're not entitled to designate stuff as proprietary when it's really not. But really, it's not in their, and it may be in the short-term interest, but it's certainly not in their long-term interest, because the government money is good, reliable money. The government is a terrific customer. Because I spent a couple of years with a commercial aerospace company with both commercial and government customers. The government customers the government prints the money, right? So the government is a terrific customer. And the government money should be used to advance the technology for government and industry to raise the level of all, right? pretty simple. You know, if you're talking about real commercial products, then that company is going to retain the source code and the rights to it. But if the government, look at this next slide, you see some military aircraft, you see one of those phased array radars, you see NORAD Northcom, just for example, you see some different kinds of satellites there. The glue code, the code that is written to connect those things, missile defense software, and so on. The things that are defense specific, we paid for the development, so we should not see proprietary markings on it, right? So looking at this slide, control, possession, rights to technical data and software can be a challenge to competition. Sometimes we don't know exactly what we need. That's bad news. Sometimes it's mismarked. The government has limited resources to correct the problem, but we'd rather use the money to advance the technology rather than repurchase the data and software over and over again. There's an example of a mismarked piece of data, and here's a laundry list of the types of things I've seen in different jobs. And I've been on the acquisition side, the PEO, ACAT, large acquisition side, buying satellites, large systems, and I've been out on the sustainment side too. And you'll see things like this, like these titles here, that are specific to military systems that are labeled proprietary to the contractor. Probably, obviously they're trying to maintain a sole source position, or maybe they just made a mistake, right? But it is not to anybody's benefit to not make that available, right? So here's a good news slide. Most of the time, even though it may be marked proprietary, oftentimes we have unlimited rights that we just haven't yet enforced. Why? Because we paid for the development of those systems. It's also good news that the government and program offices and attorneys, we do want to respect the rights of technology developed and leveraged by the commercial marketplace, such as this example of a blade server here. So sometimes you need examples, and you need to, at different levels of the procurement chain, in the operational world, you'll see, very obvious examples of mismarked data. And here is a DFARS provision 252.227.7013 with an excerpt there that the non-conforming markings has to be removed at the contractor's expense. And as painful as it is for some people to, I'll give you a story from a senior course I took a couple years back. And the instructor, who was not a procurement guy, said, we could have all these great space systems if it weren't for the FAR, so I don't know if that means just OTA or just no terms and conditions whatsoever. And I was a junior guy in the room, but I just had to, he tweaked my interest there, and I had to say, all right, so what's your experience in procurement? Well, I don't have any, but I know that the FAR has too many words. He said, and I managed a contract once, and it was an inch thick. And I said, well, have you ever bought a house? It's about 2 inches thick. You're talking about a $10 million contract with an inch thick of documentation. That shouldn't be too burdensome. But sometimes people pretend that it is. This simple excerpt from 7013 shows the laundry list of things that the government has to get unlimited rights to. Yet we get systems delivered, and we get systems that are in sustainment where they try to put contractors try to put limitations when that technical data, be it a user's manual, test data, whatever, form, fit, and function data to help you compete further sustainment. These definitions aren't really that hard to apply. So I make save a lot of money for the government applying these out in contract law world. And I should have mentioned, I should have introduced myself, that I work with the Contract Law Field Support Center, but my day-to-day job is supporting the Defense Technical Information Center across DoD and many Homeland Security programs with respect to technical information. So I get a lot of hands-on work with this, everywhere from DoD labs, product centers, COCOMs use our contracts to obtain technical data, and it needs to be unlimited rights data where it is where appropriate and where the government pays for it and where it's necessary. Go into this slide. So what does the Defense Technical Information Center do? What do we need to do with technical data? We need to be able to transfer it from program to program, sometimes from government to the public. And we also, technology needs to transfer, once military technology has gone out into the commercial sector, if it's commercial, such as, think of jet engines in the 50s. Those were military creations that were developed on the military budget, but, the commercial airplane market took that to the next level. And so that's the kind of stuff that needs to happen with some IT. It's all important policy, tech transfer, a variety of mechanisms. All this stuff is tech transfer, contracts, grants, CRADAs, OTAs, all of it. So jumping to the next, that's the 50-foot day-to-day doing the job of tech transfer and enforcing government rights. And now let's go up into outer space, right? So the segue here is $1 billion or $100 million DoD program the best way to get the government mission satisfied? Well, in this case, in the case of SSA, Space Traffic Management, Space Situational Awareness, the need, and you're going to hear from the other speakers on this, I think, about interagency coordination, NASA, Department of Commerce, and so on, that standards and international standards are the way, transparency to obtain a safer orbits, right? So thinking outside the box, is $1 billion program the best way to set the technical standard for SSA sharing? Is there a good mechanism for ISO standards? Yes, there is. The 2018 Space Policy Directive 3, SPD 3, was building upon, it wasn't just that administration's sole, change. There was a 2010 space policy that ensured that it's a national policy for all the agencies, Commerce, DoD, NOAA, FAA, et cetera, to ensure the availability of space-related industrial capabilities. So SPD 3 made the move of SSA from a longtime DoD responsibility to a Department of Commerce responsibility. FCC is an independent agency, not part of the executive branch, but it has the authority to issue draft rules, and it did so last spring. And I have a link to it there. It's called Mitigation of Orbital Debris in a New Space Age. So are Commerce and FCC the right organizations to lead the regulatory charge? I submit yes. There's a term used for FCC's regulation of telecommunications. It's light regulatory touch that protects the radio frequency spectrum from misuse and from jamming itself, and allows the wireless digital, allows us to have these these terrific cell phones that do all this stuff. They reallocate spectrum when necessary, and they regulate the power and the use. So Commerce and FCC have the authority to act in accordance with their roles, regulating licensing frequency in both launch and on-orbit operations involving U.S. licensed entities. So when the DoD was trying to run SSA and did very well, it struggles with the, how does it legally enforce what it does? Does it have an enforcement authority as the DoD? The department, being that space has a large proportion of commercial traffic in addition to government traffic, I would put forth that, like the internet and like the radio frequency spectrum, the Department of Commerce and through the Department of Commerce, through the National Telecommunications Information Administration, the NTIA is subordinate to the Department of Commerce, and they take into account the executive branch considerations on spectrum use, and they represent the government, the executive position to the FCC in rule setting. That this change of SSA standard setting and development from the DoD to the Department of Commerce will allow full realization of safe space operation, right? With all the interagency processes that you'll hear more about later. This is relevant to the procurement setting, because when we can buy commercial, when the DoD can buy a commercial capability, such as modeling and simulation and the tracking of orbital objects when it's available, that is the preferred method, because why is that? Because the unit cost is lower and the price is set by the commercial market. So I put forth that, further, that the FCC has the ability to regulate even non-US space entities when those entities want to enter the US commercial market. So their reach is broader than the voluntary sharing agreement that you heard Rear Admiral Bernanke discuss in the DoD SSA sharing agreements. So there's kind of my final point there, that the proposed rule is a potentially important advance for existing space traffic management law that could make space safer. And I won't read it there, but the processes of the Department of Commerce and the FCC have the potential to advance SSA and STM technology more than a government program. Just like the government got the ball rolling with commercial jets, with government military aircraft, but then commercial air traffic took that technology through technology transfer and put it up into the upper atmosphere. So now is a good time for commercial use of originally military developed technology by transfer of responsibility to the Department of Commerce and the FCC to create a safer, for national defense, safety, productivity, and so on, like has been, and I think you will hear discussed, that orbital debris, orbital traffic is a critical need for our space law or international law colleagues. So we've discussed data rates and tech transfer and cross-discipline legal coordination. And I hope that's helpful.
All right, thank you very much, Matt. I really appreciate the the reminder for some of the basic blocking and tackling of procurement law work on IP, of making sure that we're getting our data delivered with conforming markings is such a critical thing. It seems with these billion-dollar programs, you wouldn't think that something like that would prove such a critical thing, but I think you're absolutely right that is is something that often a lot of money can turn, and it's something that we need to be ever vigilant about. And so I really appreciate the discussion.
We need to make sure we're cross coordinating between operational contracting, SMC, AFMC, and even within AFMC. I've seen times when you're dealing with commercial software, but they don't get around to calling Gunter, the guys who have the expertise in commercial enterprise licenses, and sometimes we'll end up paying for stuff that we've already paid for elsewhere.
Oh yeah. All right. Well, I
Damon?
think our time is up. So I guess back to the conference organizers.
Great. Thank you so much, Mr. Richardson, and thank you to all of our distinguished panelists here on the acquisitions panel.